It's 6 o'clock. I'd like to call the Rock County Board of Supervisors meeting to order on this 16th day of November, 2023, and ask Supervisor Sutherland to read the invocation and lead us in the Pledge of Allegiance.
A single footstep will not make a path on the earth, so a single thought will not make a pathway in the mind. To make a deep physical path, we must walk again and again. To make a deep mental path, we must think over and over the kind of thoughts we wish to dominate our lives. Written by Henry David Thoreau. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, that's really cute. They knew exactly where.
Lisa, please call the roll.
Beaver. Bob Zine. Here. Baumkamp. Here. Bryan. Here. Clayson. Crary. Here. Cullen. Here. Davis. Holman. Here. Knutson. Here. Levy. Here. Mulwiney. Here. Peer. Pennycook. Here. Rashkin. Schneider. Here. Schulz. Here. Stevens. Here. Sutherland. Here. Sweeney. Here. Tillman. Here. Towns. Here. Whitledge. Here. Wilson. Here. Winter. Woodman. Here. Zajac. Here. Zorel. Here. Bostwick.
Here.
25 present, 4 absent.
Thank you. Next item, please.
Next item is consent agenda. 4A, adoption of agenda. 4B, approval of minutes from October 26, 2023. 4D, recognition of county employees or others. D1, recognizing Judy Hansen. D2, recognizing Randy Frost. D3, recognizing Sheila Grady for services to Rock Haven. Items that were pulled when the agenda was amended are 11E, allocating ARPA funds to reduce the risk of human trafficking in Rock County. 11K, advancing responsible leadership through voluntary drug testing. 11L, establishing a policy on inclusion in line numbering and resolutions. 11M, resolution for performance-based financial responsibility incentives. We're also pulling 11H, modifying the American Rescue Plan Act, Small Business and Nonprofit Grant Fund Program.
Any questions on items on the consent agenda? Supervisor Bryan.
Supervisor Bryan, could you turn your microphone on so people can hear you at home?
For item D3, I was understanding that Sheila Grady was going to be here at the meeting tonight.
We don't see her here this evening. We've been watching for her to come in.
Okay, thank you.
Any other questions on items on the consent agenda? Any objection to items on the consent agenda? Seeing none, consent agenda passes. Next item, please.
Next item, item 5, public hearing. 5A, amending Chapter 5 of the Rock County Code of Ordinances, Parks, first reading.
Declare the public hearing open. Is there anyone here wishing to speak on this topic tonight? Is there anyone here wishing to speak on this topic tonight? Is there anyone here wishing to speak on this item tonight? Seeing no one, declare the public hearing closed. Next item, please.
Next item, item 6, citizen participation, communications, and announcements. We have one person signed up to speak this evening. Please come to the podium and state your name and municipality. Max Olson.
I'm Max Olson. I am from Milton. Good evening. I'm a freshman at Milton High School, and I'm also the high school representative to the Milton Parks and Recreation Commission. I'd like to thank you all for the opportunity to speak before you tonight. I'm speaking tonight in support of the resolution to establish an ad hoc Youth in Governance Exploratory Committee in Rock County. Firstly, I'd like to thank Supervisor Wilson for his diligent work on this resolution, and I'd also like to thank our co-sponsors for this, for their support. By incorporating our youth in the decision-making process in government, we can learn fresh perspectives and new ideas on topics from a variety of issues. And in addition, a youth in governance program would also serve as an immense educational experience for our youth in the county, from leadership to communication to rules of order and pretty much everything youth would be able to gain is immense. It would also instill a strong sense of civic engagement and civic responsibility in our youth, and beyond that, it would give youth a sense of ownership and a sense of responsibility and belonging in our community and in our government, which is crucial to youth and their understanding. This committee would be tasked with exploring various methods of youth involvement in government, and we can take from examples from various counties in the state which have similar programs, Racine, Kenosha, there are a few others among those which have similar programs. And by supporting this resolution as supervisors, you are supporting an investment in our youth, in our community, and in our future. Thank you.
That was our last speaker signed up to speak this evening. Is anyone else in the audience wishes to speak?
Are there any supervisors with communications tonight? Any supervisors? Supervisor Bryan?
Thank you, Mr. Chair. On November 28th is Snow Driver Appreciation Day in Wisconsin. Governor Tony Evers has proclaimed Monday, November 28th as Plow Driver Appreciation Day in Wisconsin to remind motorists to give most snowplow drivers plenty of space to complete their jobs safely. We're grateful for the snowplow drivers throughout the state who work around the clock to clear Wisconsin's state and local roadways to ensure safe driving conditions every winter season.
Others? Supervisor Knutson?
Thank you, Mr. Chairman. I'd like to invite everyone out to Orfordville, Saturday, December 2nd, to the American Legion. We have our 25th annual Children's Christmas benefit. We're starting the evening out at 6 o'clock with a free pork chop community dinner. 7 o'clock, Santa Claus will be there for the kids. We have live music all night long. It's a family-friendly, fun night. Welcome in the holidays. Join us. Thank you.
Thank you. Others? Supervisor Tillman?
Thank you, Mr. Chair. I'd like to call your attention to a flyer that I had placed at your desk. The Rock County Sheriff's Office and the U.S. Department of Homeland Security, Cybersecurity and Infrastructure Security Agency, and the U.S. Attorney's Office are hosting a free training here in Rock County on November 29th about protecting places of worship. I've had quite a bit of interest from the local churches and organizations, and I just wanted to make you aware of it in case you want to contact anyone in your faith circle that might want to attend. Thank you.
Others? Supervisor Zorro?
Thank you, Mr. Chair. Citizens of Rock County, a document filled with unfounded allegations has been circulated within our government, designed to smear and disrupt rather than to address any real issues constructively. It's a tactic that has no place in the halls of our administration, which is built upon the principles of integrity and transparency. To the staff and board members who are complicit in the approval and distribution of this material, you have not only violated the trust of the public, but the spirit of our democratic process. I'm calling for your immediate resignation. We cannot allow the important work we do to be tainted by such irresponsible and divisive actions. Rock County is a community that stands strong in the face of adversity, and it's time to rid ourselves of those who do not share our commitment to honest and straightforward governance. Step down now, so we can continue to build a community that reflects the best of our values. Thank you.
Others? Anything from staff? I have a couple of quick things here. First off, our next meeting will be at the Daniel Hale Williams Resource Center. That'll be on December 14th. There will be some construction going on here in this courtroom, and we're not sure that things will be put back together in time for our meeting. So again, the next meeting will be on Thursday, December 14th at the Daniel Hale Williams Resource Center. Same time, 6 o'clock start. And the other thing is, for all of us heading into the woods for the hunting season, which opens up on Saturday, best of luck and please be safe. Next item, please.
Next item. Item 7, nominations, appointments, and confirmations. Item 7A, appointment to the Ad hoc Committee on Passenger Rail Development.
Moved by Supervisor Sweeney, seconded by Supervisor Holman. Discussion? This is roll call. Please vote.
Yes, 25, no, 0, 4 absent.
Next item, please.
Next item, item 7B, appointments to the Ad hoc Committee on the County Board Supervisors Rules of Procedure.
Moved by Supervisor Crary, seconded by Supervisor Zajac. Discussion? Supervisor Zorro?
Thank you, Mr. Chair. On this particular committee, there were 7 people who applied for 5 open positions. There were 2 supervisors who were not chosen that I believe are more qualified than the 5 that were. On that basis, I don't want to vote against all 5 because that wouldn't be fair. Rather, I move to divide the questions so we can vote on them one by one.
Is there a second? Moved by Supervisor Whitledge. Discussion? Okay, we have a motion and a second to divide the appointments to the Ad hoc Committee on County Board Rules. This is roll call. Please vote.
Supervisor Towns and Supervisor Zajac. Yes, 6, no, 18, 4 absent.
Back to the original motion, and that is appointment to the Ad hoc Committee on the County Board of Supervisors Rules of Procedure. Additional discussion? Supervisor Zorro?
Thank you, Mr. Chair. While I wish that I'd be able to vote for at least some of these appointments, I'm going to unfortunately have to vote no on all of them, but I don't want that to reflect that. That's a no vote on all of them. In reality, it's only the ones that haven't been following our rules, because I don't believe we should be appointing people to make rules when they don't know how to follow them in the first place.
Others? Supervisor Crary?
Thank you, Board Chair. I just want to go on record as saying that there's been a lot of times that the rules have had to be interpreted and explained, and one person's perception of a rule at times is different than what it actually means. So all 5 will have my vote. Thank you.
Others? This is roll call. Please vote.
Yes, 22, 3 no, 4 absent.
Next item, please.
Next item, item 8, recognition of county employees or others. There are none. Item 9, introduction of new resolutions or ordinances by supervisors for referral to appropriate committee.
Are there any supervisors wishing to introduce a new resolution? If so, please bring them forward at this time. Supervisor Zorro, will you give us a brief description of your proposed resolutions?
Thank you, Mr. Chair. There's 4 resolutions. First one is resolution to clarify county board rules regarding budget modifications. This resolution updates an existing board rule to clarify that the Finance Committee can only offer an endorsement or any modification to any budget, including the adopted budgets and proposed budgets, if the matter was recommended for approval or adoption by a standing committee of the board. Resolution 2 is a resolution for Rock County's transparent budgeting and 5-year tax roadmap. This resolution directs the county administrator to create and maintain a 5-year property tax levy estimate. It'll be updated twice per year, so our taxpayers have an estimate on what to expect their taxes to be in the future, the same way our employees have a wage grid that they can use to estimate their future earnings. Resolution 3. Resolution for the trial implementation of zero-based budgeting for fiscal year 2025 in Rock County. This approach marks a shift towards meticulous financial scrutiny, requiring departments to justify all expenses from a baseline of 0. It's a trial for 2025, aimed at assessing the method's effectiveness and ensuring taxpayer funds are used efficiently and effectively. Furthermore, this process includes transparent communication about state-mandated and non-mandated services and their funding sources. Importantly, this initiative involves active engagement with the community, ensuring your voices are heard in decisions impacting county services. And the 4th and final resolution is titled, A Resolution Protecting Taxpayers by Setting a Responsible Tax and Spending Cap for the 2025 Budget. This resolution directs the county administrator to recommend a spending cap and a tax levy cap for the 2025 budget. It is due to the county board by June 1st, 2024. At that time, the county board can choose to direct the county administrator to prepare the 2025 budget in accordance with his recommended cap. The board can set a new cap, or the board can set no cap at all. Thank you.
Any other new resolutions at this time? Next item, please.
Next item, item 10. 10A, use of social media by elected officials, Andy Phillips, Atolis Law, Sarah Dietrich Kasdorf, Wisconsin Counties Association.
Okay, as advertised before, many supervisors use forms of social media, and along with that comes a lot of questions about what's legal, what's ethical, so forth. So we are lucky to have Sarah Dietrich Kasdorf from the WCA and attorney Andy Phillips, who also works with the WCA, to give a presentation and answer any questions that people may have. I believe if you have questions as we go along, you can ask them then. They will be calling on people for the questions.
Awesome. Thank you, Mr. Chair. Good evening, everybody. Thanks for having us here tonight. I'm Andy Phillips with Atolis Law. Glad to see all of your faces. I've seen many of you before at various events for the Counties Association. By way of background, I've represented the Counties Association and county governments throughout Wisconsin for most of my 28-and-a-half-year career. And so working with counties is always a privilege. I love it. But I will tell you the most interesting part of my job is that not a single week goes by where I don't learn something new about counties that I didn't know the week before. And so I was discussing a little bit before this presentation with Sarah, and Sarah will be up here to give her speech in just a little bit. She's laughing at me because she's not gonna leave her seat tonight. This is the first county presentation on use of social media that I have given. So you guys are trailblazers. You should feel very, very proud of yourselves on this. I give this presentation quite a bit in schools with our school district clients. As you might imagine, there's an awful lot that goes on with students and teaching staff and board members and community as it relates to First Amendment rights, social media use of public forums, and so on. And so this is a discussion. It's not a presentation. I don't fancy myself a First Amendment lawyer, a social media expert. My kids have taught me enough to be dangerous about social media, and that's as far as I go. And so if you have questions and want to discuss particular items, even if you want to disagree with me, that's okay. We can have a discussion tonight just so everybody understands exactly what it is we're talking about. From my perspective as a lawyer that represents county government throughout the state, what my concerns are as it relates to use of social media. So, in my mind, again, when we're talking about social media use by elected officials, three primary considerations. We have this thing called the First Amendment in this country, and the First Amendment guarantees the freedom of speech, but that freedom of speech is not unlimited. So what are the boundaries on freedom of speech? And in that circumstance, I'm talking about two different things. What are the boundaries on freedom of speech as it relates to the elected official who is engaging in utilizing social media to convey a message and receive feedback from constituents? And then as well, what are the First Amendment concerns as it relates to a constituent that may post something onto an elected official's social media site, website, whatever that may be? Are there restrictions in terms of what we can do to limit the public's ability to interact with us through social media? So we're going to talk about those two things under First Amendment concerns. Second and third are really the transparency in government rules in Wisconsin, open meetings law and public records law. And I don't know if you all knew this, but social media was a lot different in 1981 when those laws were written than it is today. All right, and so I joke, but these laws are antiquated when it comes to technology. For crying out loud, they had to issue updated guidance through the Attorney General's office to deal with video conferencing technology. They didn't even anticipate, nor could they have anticipated, use of social media. But nonetheless, even though the law didn't contemplate social media when it was written, it is still, the law is still applicable to social media. So we got to make sure that whatever we do on social media as elected officials complies with public records law and open meetings law. So let's start with First Amendment concerns. And the First Amendment can be a very complicated area of the law, as is any constitutional area of the law. I've got a case right now in my office where we're dealing with defense of a county on a First Amendment claim. Incredibly difficult to really put together in a very digestible format in a 10-minute discussion about the First Amendment, but I'm going to do my best here, all right? So, when we look at the First Amendment in Article 1, Section 3 of the Wisconsin Constitution, we cannot, as government actors, abridge the freedom of speech, all right? So we start with this very fundamental premise that we can't take action as a government entity abridging another citizen's right to freedom of speech. That's the fundamental premise. So when we look at what is it that triggers First Amendment concerns, it's always going to be state action. And when I say state, I mean government. I mean county, state government, local government, whatever. There has to be state action, government action in order to trigger a concern under the First Amendment. So the very first thing that I look at when it comes to use of social media is who's using social media. Is it a private citizen? Or is it a public official who either in reality or in appearance is speaking on behalf of the governmental entity, all right? If it's somebody that's speaking on behalf of the governmental entity, it's really difficult then to regulate what it is that occurs on that social media site. Why? Because again, the government cannot abridge somebody's freedom of speech. And so the concern I have is that, and there have been cases on this too, where people have been sued saying that when you silenced me on Twitter and blocked me, and there are some very public figures out there that are rather famous for blocking people on Twitter, all right? I'm not going to name names, but it rhymes with Trump. And so when we look at situations like that, was President Trump utilizing Twitter in an official capacity as President of the United States? Or was he using Twitter in his capacity as a private citizen, for example, in the context of his campaign? And where is that line drawn? And I'm telling you, it's very blurry, and it's not easy to figure that out. And the cases that I have looked at on that question of is that official speaking in an official capacity or speaking in a private capacity, it's a really long case because there are all sorts of factors that courts go through to make that determination, all right? So I say here, it's really hard for you all to take off your county board member hat and just step into a seat in the back and act as a private citizen as opposed to acting as a county board member. So keep that in mind when you're utilizing social media, because appearance does matter. Your intent means nothing. It's the appearance that matters, okay? So again, if you're speaking on county business, you cannot regulate somebody else's speech. You can't delete, remove comments, you can't block people. You're going to find yourself with a First Amendment problem. When you open a page to the public, you're limited in the regulation of that page. And so if you have a Facebook account and you want to limit the comments that come in, delete some, wipe some off, you have to be very careful about doing that, because if you're speaking as a board member, that individual may have a claim against you for violating his or her First Amendment rights as a result of your action in silencing them, okay? So I'm going to ask a very silly question here. Don't hold it against me. Can you turn comments off in Facebook? I mean, just absolutely turn them off? You can, okay? I'm going to verify that with my children tonight when I go home. But if you can turn comments off, awesome. You can flat out prohibit anybody from commenting, but you can't pick and choose who gets to comment, all right? So if you have the ability to limit the content that comes onto your social media page, I would suggest to you, and I think your corporation counsel would agree, limit the amount of information that comes back to you. And we'll get more into why that's important later when we talk about our open government laws. Yes, sorry.
You just said you can't pick and choose who comments. So to clarify on that, would that include, let's say, people that are not your constituent, they don't live in your district, you don't represent them? And does that also include, let's say, between board members? In other words, if there's a fellow board member who has another board member blocked, what about that?
Anytime you engage in the pick and choosing, the selection of who has the ability to comment, you run into danger. I can't give you a black and white rule as to whether a particular block or a particular deletion is going to pass constitutional muster, but anytime you engage in that type of activity, you're in legal jeopardy, and I would be concerned. I'll put it that way. Regardless, doesn't matter where they live, doesn't matter if they're in the United States, they're a citizen, they have rights under the Constitution that you cannot abridge. All right. I want to emphasize this last point too. Social media posts are considered speech, but not all speech is protected under the First Amendment. All right, and the often quoted, and it's actually often misquoted, saying is you can't yell fire in a crowded theater. Rich, you know that you can say fire in a crowded theater, but you and I spent 3 years in law school understanding why that's a misnomer. All right, but that's the most famous exception to the First Amendment. When we say that not all speech is protected, it's not. I'll give you a great example. My daughter is flying back from Alabama tomorrow. When she walks in through TSA, can she say, wow, that's a really cool gun that you got there? Nope, she's going to get in trouble for saying that. But wait a minute. She's engaging in free speech. How can the government regulate what she is saying in that line? Well, the governmental interest that exists in ensuring that we have safe travel on our airways outweighs an individual's right to protected speech in that circumstance. I say all of this to let you know that all of these rights, none of them are absolute, okay? So we have to look at from a forum analysis. And when we talk about the First Amendment, there are really 3 types of different forums under the First Amendment. And there's the traditional or the public forum. There's the limited public forum, or what people call designated forum. And then we have non-public forums. And the easiest way to remember this is that I always think of the traditional forum as the courthouse steps or the sidewalk in the public park. The area where we know as citizens of the United States, we have the greatest guarantee of freedom of speech anywhere in the country, where we traditionally think about people stumping, having discussions, engaging in debate, engaging in dialogue. Those are your traditional or public areas. That designated forum under the First Amendment is entitled to the most protection. It is only in very limited circumstances that the government can regulate an individual's speech, if that speech takes place in that type of forum. Then we have limited, public, or designated forums where we have an opportunity as a government to allow people to speak. We're given that opportunity, but it's not wide open. It's not the courthouse steps. It's not a sidewalk in a public park. Great example of that is when we ask an individual from the public to step up to that podium and provide us with public comment. It's a limited public forum. The law does not require us to open that podium up at a county board meeting, but as soon as we do, they have First Amendment rights, but those rights are not as great as the rights of somebody who is speaking on the sidewalk or the courthouse steps. And then we have non-public areas where speech is not traditionally invited, and we didn't intend to invite speech. We can regulate the heck out of that forum. We still have some restrictions on what we can do. We can't exercise viewpoint discrimination. It has to be neutral. But as long as we have some sort of rational basis for regulating that speech, courts are going to recognize that that's okay. So you look at this and you say, well, what does it matter? I mean, honestly, it's really impressive, Andy, that you're giving us the breakdown of the 3 different forums that exist under First Amendment analysis. But why is that important? Well, it's important because, again, we're dealing with new technology here with social media, and the courts have not resolved with any clarity what social media is, what type of forum it is. Because remember, I said if social media is determined to be a traditional or a public forum, it's entitled to the greatest level of protection. That means that we are very restricted in terms of what we can do in terms of regulating the content on that social media page. If social media is considered a limited public or designated forum, we have a little more flexibility to enact reasonable regulations that serve a legitimate governmental purpose in regulating that speech. So there's a big difference between those two, and the courts have not given us the guidance necessary to say, okay, this is how we're going to look at it. So my advice is, again, let's be very, very conservative in our approach, and let's act as though it is a traditional or a public forum, meaning that we are going to take a very circumspect approach in regulating that type of speech, all right? So again, there's been a Supreme Court case that kind of spoke to this question, but as you see on the slide there, is that there was disagreement among the justices in the Supreme Court as to how to treat the speech on social media. So what's our framework for analysis as it relates to First Amendment concerns? First question we've talked about already. Is the board member acting under color of state law or in his or her official capacity when they make that post, the comment, blocking somebody from the public, deleting other comments, or engaging in other social media action? If the board member is not acting under color of state law, we don't have a problem. We don't have any issue because I'm a private citizen. I can restrict your speech all I want. I am not required to provide you with any sort of constitutional right. But if I'm a county official, I have to be very careful about what I do in terms of abridging your right to freedom of speech. And so again, first question, are you acting in an official capacity? As we'll see later, we'll get into this, but sometimes even if you think you're not acting in an official capacity, a court might find that you were, because again, looking at it objectively, through the eyes of an objective person, was there a reasonable belief that you were acting in an official capacity? If the answer is yes, guess what? You're acting in an official capacity. All right, if the board member is speaking as a citizen, and this is step 2 here, where if, as a board, we want to regulate one another's social media content, or the county adopts a rule relating to social media, if the board member is speaking as a citizen, the board wants to regulate the content, is the speech on a matter of public concern or private concern? Again, differentiating between an individual's private interests and an individual's interests in the public issues at large, all right? In the public concern situation, if you want to discuss the issues of the day that are confronting our state government, the federal government, and so on, you are entitled to protection from government interference with that speech. so long as you limit your commentary to matters of a public concern. But as soon as you want to start talking about matters that are purely private to you, say that you've got a grievance pending with Rock County and you want to air your thoughts on this particular grievance with Rock County, that's not entitled to protection under the First Amendment because that's a purely private concern, all right? So again, step one, in what capacity are we talking? Step two, is it a public or a private concern? Step three, if the matter is a public concern, is the board member's interest in commenting on these matters of public concern, does that outweigh the board's interest in promoting efficiency and harmony among the board members, all right? So that's a really good question. And this, without really getting into the weeds of the legal analysis, this is what we're getting at, is what is our interest in regulating a board member's commentary on social media, all right? Is there a harm that is going to result from the board member utilizing social media in the way that he or she does? What is that harm? Is it going to cause disruption? Is it going to cause a problem? We're going to have to quantify that if we want to regulate that board member's speech, all right? So some of the attributes you can look at a board member's duties and committees that are served on, the context of the speech, intra-board or county disputes, communications of public concern generally merit a greater degree of First Amendment protection. We've talked about that. And the need to balance the speech by a board member with the need of the body to organize and control its own affairs, all right? So again, none of this is capable of a black, white rule. Good, bad, whatever you want to call it, there is no bright line that says and separates good conduct from bad conduct. It's taking all the facts and circumstances associated with a particular situation, wrapping them up and going through the analysis under the First Amendment to determine what is it that is the government's interest, what is it that's the private citizen's interest. All right, so that's it for the First Amendment overview. I've got a couple of cases. In fact, I'll go to the cases here too, because these are First Amendment cases. And these are two different cases with different outcomes, and they highlight some of the principles that we've just discussed. Campbell versus Reich. Missouri State Representative blocked somebody from her campaign Twitter account. The court held that because the Twitter account in question was a campaign account, the representative had not acted under the color of state law when blocking the user. Court found that the representative's Twitter account had remained focused on campaign news rather than on communicating official news or inviting constituents' input on policy issues. And because the representative was not acting in an official capacity when blocking users from the site, the court didn't apply that traditional public forum analysis, which calls for strict scrutiny, which is, again, that forum is entitled to the most protection under the law. Now, having read this case, gone through this case, there's a whole lot of discussion in that case that goes beyond these 4 bullet points. The court looked at every single Twitter post. The court took testimony from witnesses about what they were posting and what their intent was on use of this site. As you might imagine, the individual that was blocked said, this representative is using this site for much more than just campaign news. This representative is communicating with constituents. This representative is doing all sorts of things that you would expect a representative to do in terms of communicating with the public through the Twitter site. And then the representative herself talked about the use of that site for campaign-related issues. The representative also pointed to other sites that were utilized for official communications as a state representative in Missouri. And so a separate Twitter account existed in this circumstance for those official communications. The court sided with the state representative, but I can't tell you it was easy. If it was easy, it wouldn't have required all of those pages of a decision to go through the analysis. And so this was a situation where the court sided with the state representative, said that you have the ability to regulate your Twitter account because you were acting in a personal capacity, not as a public official. Contrast that with the Davison v. Randall case. In that circumstance, and this is from Virginia, a county board supervisor was acting under color of law when she blocked a group organized by a constituent from commenting on a Facebook page that she created as a tool of governance to provide information to the public about county board activities. The court applied the public forum analysis. Look at the title of that Facebook page, a tool of governance. That screams official capacity. And so from every outward appearance, I don't care what you say about it being your personal page. If you're going to talk about it being a tool of governance, that's an official Facebook page. And you're going to be very limited in terms of what you can do in regulating the content on that Facebook page, all right? Court concluded that the board supervisor had unconstitutionally abridged the constituents' freedom of speech by engaging in viewpoint discrimination, which is not allowed in any type of forum, all right? Again, the court didn't decide exactly what type of forum it is, and it dodged that question, but it said, I don't care what kind of forum it is, you can't do what you did here by blocking that particular person or deleting comments. So, we have two competing cases on similar fact situations. And I will tell you as a lawyer, and I think that your corporation counsel would agree, our goal is to keep you out of court, all right? The way you keep out of court is to avoid these situations altogether. And I think one of the issues that we've got in the law, and this applies whether we talk about the First Amendment or we talk about the open government laws in Wisconsin, is that it seems that we are a bit handcuffed in trying to communicate messages out to our constituents. Because the easiest way to get the word out nowadays is through social media. And yet, Andy Phillips is sitting here, Mr. Greenlee is sitting there saying, avoid the use of social media. Don't do it. It's just too risky. And so that's a real problem. How do we figure out how we blend those concepts and we responsibly use social media so that we don't find ourselves in court, but yet we are still able to get out the messages that we want to get out to the people that we serve? I don't have the answers on that. That's why you all get the big bucks, is you get to figure that out, all right? There's usually more laughter when I talk about county board supervisors getting big bucks. But it's a difficult analysis, and I say all of this to reinforce the need to speak with your corporation counsel a lot when you're engaging in these types of activities, because it's his job to make sure that we don't find ourselves in legal hot water as a result of use of this technology. Yes?
What would you do in a situation where corporation counsel refuses to speak to you as a board member?
I guess I'd want to know more about that. I don't know how to react to that. I really don't know.
Yeah, I don't know either, but thank you.
So when we talk about what we want to go through here as it relates to potential litigation, you might say, okay, so you know what, this Davison won in court. So what are we going to do? We're going to restore the comments that were deleted off of Facebook. We're going to allow Davison to comment on this. What's the big deal? Randall lost. Well, guess what else Davison got as a result of this judgment? Money. Money, damages. And you might say, oh, okay, well, how is Davison really damaged? So, okay, fine, so pay $10,000. That's money, that's damages, that's fine. What's the big ticket item here in any constitutional claim? Attorney's fees. There's this thing called 42 U.S.C. Section 1983, which says that any time you find yourself in court on the losing side as a defendant on a constitutional claim, you owe the other side's attorney's fees. That's a big ticket item. And if you pull this case and see who was representing Davison, there's a lot of law firms there. One of them was David Boyes' firm. Do you guys know who David Boyes is? He kind of makes a lot of money. His hourly rate is a little bit more than mine and just a hair more than Mr. Greenlee's, all right? He's high priced. And so it's an expensive proposition. So we have the extreme privilege of paying our own lawyer to go into court and then the risk of paying the other side's lawyers too. That stinks. That stinks. So, I mean, it can be a big ticket issue. Excuse me. So again, we've talked about the First Amendment. Why don't I pause there and see if we have any comments or questions about First Amendment concerns. Everybody's a First Amendment expert right now, right? Yes, ma'am.
So I just have a question. So I have my private page, which is, I mean, my page, personal page. I have a campaign page, and then I have an official county board page.
Yep.
99% of the time on my personal page, I do not discuss county business at all.
So
I
why
might
do you do it
occasionally-
1% of the time? That's my question.
I might occasionally talk about my opinion on some of the things that have happened with a vote, but I feel like it's my own personal opinion as a citizen of Rock County.
Okay.
Sometimes some people might teeter over there to have something to say, and it can get a little nasty. I won't say how I've responded to that. So kind of give me some advice on what, with the campaign page, you kind of went over the case of the campaign page, that it was ruled, since you're using it as a campaign page, that person deleted content. I don't delete things from my campaign page or my county board page. But let's say you do have somebody who's using their campaign page and they're saying, I can delete things from my campaign page, even though it has now been transferred to being used as, it really is being used as their county board page. But there's still two different pages that are being used. Basically, both of them are really being used.
Sure.
How does that work?
Okay, a few concerns that are wrapped into that question. And so, again, is it Facebook that you have the three
Yeah.
different pages? So do you have the ability in Facebook to name these different pages and describe them, like put at the very top, Stevens for Supervisory District 13 campaign page? If you have comments
they've
about this, then you should go to this other page and provide a link. Can you do that?
Yep, they've
Yeah.
all been very clearly defined. This is.
Yeah, I was kidding, by the
Stevens
way,
for
when I
county
said
board.
that. I know you can do that. And so you need to do that. You need to label these pages, and you need to direct people as much as possible to the other page, if you maintain that page as an official county board-related business page. Direct them to that official county board-related business page, because I'm going to get into public records issues here in a moment. That official page, that's a public record. And we have an obligation. You're an authority. Whether you want to be or not, you have a responsibility under the public records law to maintain that official page. And so if somebody makes a public records request for all of the comments that relate to this issue of business, you have to fulfill that public records request, okay?
What if you hide them but don't delete them?
You can hide them, that's fine, but you don't, but if somebody makes a records request, guess what?
I'll have it and I can give it to them.
They're unhidden.
Okay.
I'll put it that way. And so one of the things that you can do is that if you have a personal page and you use that page for purely personal business, make it very, very clear on that page that you are not going to talk about, discuss, accept comments on anything having to do with Rock County Board business. Same thing with your campaign page. This is my campaign page. And if you remember in the Davison case, what case was it? It wasn't Davison, it was Campbell. In the Campbell case, the state representative won because she convinced the court that that campaign page was used solely for campaign business. So make it very, very clear on that campaign page that the only issues and topics you're going to discuss are related to Stevens for Supervisory District 13. That's it, okay? Public records, I touched on this just briefly. Yes, sir.
So when you mentioned campaign business, how do you recommend drawing that line? So for example, if you're campaigning and you want voter support, et cetera, I'm out there doing the good work for the constituents, representing your interest because I want your vote, et cetera, et cetera. I voted this way because of this why, and that's the reason why you should vote for me, et cetera. So when you say, I did this because, with the intent that it's because I want your vote, is that a campaign activity or is that an official activity?
Well, I think it depends on the whole totality of the circumstances surrounding the discussion that unfolds on social media. And it's not capable, again, of a bright line rule one way or the other. As a rule of thumb, whenever you are talking about retrospection, it's a lot easier to justify as a campaign issue. If you're talking about prospective action that you may take or your position on issues that are either currently or will be pending before the board, I'd have a tough time saying that that's not an official business type communication. I would have a really tough time arguing that. And so that's just the rule of thumb. That doesn't mean in every circumstance that every sort of discussion that deals prospectively with an issue that might come before the board is automatically official. I don't want to say that. Nor does it mean that every time you're looking into the past and talking about things that you're campaigning on positions that you have already taken that are no longer before the board, that that's always going to be okay. I'm just saying as a rule of thumb, whenever you're looking forward, that screams to me more official action. Whenever you're looking toward the past, that screams more campaign-related. All right, so public records, we've talked about this briefly. All social media content-related governmental business, whether public-facing or private, constitutes a public record. If you look at the definition of the word record under 19.32 sub 1 of the statutes, it includes all written documentation, no matter the form, can be electronic in form. Well, guess what? Social media is electronic in form, and so it is going to fit within the definition of a record under the law. And so what is your obligation as it relates to that as an authority? An authority is the primary obligor under the law with a responsibility to maintain those public records. You're keeping it for 7 years. And it's on you. It's your responsibility, all right? So make sure that if you are going to have an official Facebook page, that you have the ability to produce records responsive to a records request relative to that Facebook page. Same with a Twitter account. And again, the public records law was not designed with Facebook, Twitter, Instagram, whatever else in mind. But just because these things didn't exist when the public records law was enacted does not mean that that law doesn't apply to all of that technology. It certainly does. So you got to be very careful about that. Again, it's best to have an ordinance or a rule in a county that deals with the ability to download and produce records responsive to a records request based on those official social media pages. And so would it be reasonable for the county board to adopt a rule that discusses what it is happens in the event a public records request comes in for material off of a board member's official supervisory seat social media page or website? Absolutely. That's reasonable. Can you have a rule that says that no county business shall be discussed outside of an official social media site or webpage? Yes, you can have that rule. That's okay. Now, does that completely insulate every supervisor in the county from a legal problem in the event discussions happen outside of that official page and happen on a campaign site or a personal site? No, it does not insulate you from liability. But a lot of what we're talking about here is group accountability to say this is the way that we do business in Rock County, and we have expectations about how people are going to maintain these separate sites if indeed they're going to have these sites at all. And it's up to us to police one another to make sure that that occurs, all right? Because the other issue we've got is the open meetings law. And the open meetings law has this thing called a walking quorum. And a walking quorum is considered a meeting under what's called the Showers test. Showers test, I always call it the 2 Ps. When you have enough people present to constitute a quorum, and when you have a purpose associated with conducting governmental business, the 2 Ps, you're going to have a meeting. It's there. And so we have this concept of a walking quorum. And a walking quorum is defined as a series of gatherings among separate groups of members of a governmental body, each less than quorum size, who agree tacitly or explicitly to act uniformly in sufficient number to reach a quorum. So I want, and I have $160 in my pocket right now that I want to give to you if you can tell me the difference in the definition of a walking quorum and the definition of politics. Good luck. I have not yet lost a dime on that bet. So I understand, everybody understands that it's politics when we talk to one another, trying to figure out where votes sit on a particular issue, but don't do it. And if you're going to do it on a social media site, all you're doing is creating a record of an illegal walking quorum. So why would you do that? It makes 0 sense. You find yourself on a Facebook page, you get a comment from a citizen, you see another supervisor weigh in, you say you agree, then you see another supervisor weigh in, he or she agrees too. Pretty soon you've got 17 supervisors who are all very publicly saying that they agree with a particular position that was first posted. That's a walking quorum, and that's a problem. So again, avoid it. You're in this room conducting county business tonight. Conduct county business in this room. Don't conduct it on social media, all right? So be very wary of that. So we've been this. Any questions on public records or open meetings law? All right, here are the takeaways. As I mentioned at the outset, social media is a really quick and effective way to communicate with a large number of people, but it comes with strings. What controls do we have over that forum as a county? What controls do we have over that forum as board members? What records are we creating of what's transpiring on social media? And this is a practical point. This has nothing to do with legalities. What message are we sending to the public if we are conducting business over social media, as opposed to in this room right here? If we've made up our mind by virtue of taking a social media poll before we walk through that door to start a meeting, what's the message that we're sending to the public? I don't know for sure, but I can tell you if I were one of your constituents, I would be extremely bothered if I knew that you were all engaging in social media poll taking before entering those doors and we had a predetermined outcome when you sat in those chairs tonight. That would upset me because I would want to come to a meeting, and if I was interested in an issue, I'd want to hear the debate, all right? So again, beyond the legalities, there are all sorts of practical reasons as to why we want to limit our use of social media, even though it's very convenient, even though it's a quick and easy way to communicate with our constituents. So what can we do to ensure that we don't run into these legal issues? And I don't have all of those answers. And there is no magic bullet there to make sure that you don't run into legal issues. The best thing you can do is educate yourself about these legal issues and do everything that you can to enforce group accountability to make sure that we don't have people going beyond the boundaries of what we would consider to be legally acceptable First Amendment, public records, open meetings law type concerns. All right, so any questions, comments, concerns? Mr. Greenlee, did I miss anything big? Nope. All right. Sarah, what were you going to say? There you go. I'm sorry. Yes, sir.
Why were we the first?
Because honestly, this is such a new technology. I've talked about social media use as it relates to public records and open meetings law. Your chair called. I ran into him actually at the WCA conference. I talked to your chair. And he said, he was asking me about some of the First Amendment implications with social media and things of that nature, and said that we had had some discussions at the county board level about use of social media. And he said, would you be willing to come out? He's like, I know you've done a lot of work on this issue with schools. Would you be willing to come out and talk to our county board? I said, absolutely. As long as it's not January, I'm good with that. So that's why I'm here.
Shell social media, but
Yes, sir. Yes.
A lot of times you use posts and they just get out of hand.
Yeah.
What do you do then? Do you just block everybody from that point on, but you're able to let some people comment? Or
As soon as you start blocking somebody, somebody's going to say you abridged my First Amendment right to free speech. You got to let it ride. That's the problem. That's the problem with having any sort of interaction. You can't control it. It's like having public comment with no rules and allowing people to start screaming stuff from the back, start yelling obscenities and all this, and we just got to take it. That's just, it's very, very difficult to deal with. Yes?
can you just shut down your social media stuff?
Yes.
Call it quits?
Call it quits. Absolutely. No more communications. Absolutely, you can do that. Yes?
say you see a violation, who do you report it to?
Well, I mean, and that's a good question, because it's not like you call the sheriff and ask the sheriff to enforce the law. I think it's a conversation with your board chair, your administrator, and your corporation counsel and say, we've got some issues here that we've got to deal with. How do we deal with it? And I mean, unless, Rich, you want him to call me, I know that, but.
Yeah, I mean, there's certainly been times when I've outreached to board members and just let them know, this is what's going on, this has been reported, this would be my advice. So, if you have concerns about anything happening in the county which could have legal implications, I always ask that you come to me, come to Josh, and we'll discuss it and try and figure out how to strategize to address it. And that would include anything having to do with social media use for board members, or if you have a county supervisor page and you've got a lot of problems with, constituent communications getting out of control, I'm happy to sit down and game plan how to deal with that and what to do, so.
Yeah, and I think as lawyers, I always joke that nobody ever calls my office and says, Andy, I'm doing great today. How are you feeling? I've never had that conversation, all right? It's always, oh my God, the world is crashing in, what do I do now? And that's as lawyers what our job is, so we're used to that. But to the extent you can be proactive and have these discussions, hey, I was thinking about having a campaign website. What are some do's and don'ts on that campaign website? And Rich is gonna have some great ideas about how we make sure that we don't cross the boundaries from campaign into official communication, all right? Have those discussions in advance and it makes our job a heck of a lot easier and keeps the county out of hot water. Any other questions? If not, it was awesome being back in Rock County. It's great to see you all. And if you have any questions, feel free to reach out to me, the county's association. And if you have any feedback on our discussion, because you were the guinea pigs, you were the first county. And so if you think that there are areas that we should hit on more than others, feel free to share that feedback as well. All right, thank you all.
Thank you.
Next item.
Item 10B, briefing on ransomware event.
Okay, Josh, if you'd go ahead.
No. Well, good evening, everyone. So we wanted to share with you a little bit more about the cyber event, so-called cyber event, now that we're called ransomware event now. So we appreciate the opportunity to get on the agenda, which looks like this for this part of the presentation. So we're going to run through a few things. And the three of us, myself, Corporation Counsel Greenlee, and Deputy Director of Rock IT, Dara Mosley, are going to run through these issues. So first, I'm going to talk about communication and a little bit about decisions that we made during the response and why. Dara is going to run through a timeline, talk about steps that we've taken to enhance our cybersecurity over time, our current strategy, and then Rich is going to talk a little about personal data and notification, which is kind of the next phase that we're going to be moving into right now. So starting with communication decisions. So as the cyber event unfolded that Dara will begin to describe for you in just a couple minutes, we were actively talking about what do we want to share, how can we share it with the county board. And the first thing to know is that you just saw Andy talk about the fact that state law sometimes is outdated, and there are no exceptions to the open meetings law that allow us to talk about cybersecurity or anything related to security of our systems or whatever, and Rich can answer those questions later. But the first thing to know is that we didn't have an opportunity to come to you in closed session. So then what could we share with you that would be public? Well, first of all, excuse me, the first principle was that limiting information to be made available publicly was in the best interest of the response as the response was unfolding. So number one, we had to assume that the threat actor was either monitoring local media, for example, as they were anticipating how to try to manage us, or frankly, at the time, monitoring our communications. We just, we didn't know early in the process. They have access to our emails? We just don't know. So number one, we had to assume that they were watching what we were saying. And certain things that we would have wanted to say would have put the county in a bad position. So for example, if we were to have publicly talked about which systems were accessed, what data was accessed, which of our files were encrypted, that could have allowed the threat actor more leverage over us, right? They didn't know, we didn't know if they knew the value of the files and the systems that were encrypted. And so we didn't want to talk about it because we wanted to maintain as much leverage ourselves as possible. And then, what we also could not do under a risk analysis strategy in the best interest of the organization is put out information that we did not know if it would end up in the media, if it would end up on social media. And so we just retrenched a little bit. And we had lots of lawyers advising us as well on this. It wasn't just Rich making up all this stuff, which he's very good at making up stuff. But we had a lot of advice about that, right? So that's why we were very hesitant to share a whole bunch of stuff that I know you all wanted to know. And frankly, even though the response itself is over, right? That part of the response is over. We're currently still mitigating risk by managing information. So I'll give you a couple other examples. Even though information is sort of circulating, we've made a decision not to publicly name the threat actor because we don't want to add to the internet ecosphere any other connections that people could connect dots that could lead to stuff that could negatively affect the county, right? It's just a risk mitigation strategy, even though I know that it might seem silly to you. Well, everybody knows it's out there. Well, it's not out there for everybody. It's out there for some people. If we talk about it, it could be out there for more people, and like this, right? So we're trying to mitigate risk. The other example is, we have not and aren't intending to, at least right now, identify very specifically the threat vector. How did they get in, right? We're not saying that out loud. Dara's going to talk a little bit about that, but we're not specifically naming it, even though we have remedied the specific issues that were there at the time. We don't want to provide a roadmap for anybody either, right? Well, here's how somebody got in before, so let me try that, or maybe I could try this. Maybe they didn't fix that, right? So we're going to talk a little bit about that, but we're still not going fully down that path for that reason there. So just as a reminder, I just put these two bullets up here. There were several communications that I made to you at various times. Dara will talk about when the event started, but the October 3rd is a Tuesday. That's the first communication I had with you all. That was several days after the weekend when we first sort of identified this was going on. Then updates, incremental updates. Some of those communications were about password resets. Ultimately, communication that we were not going to pay the ransom was in there as well, and that sort of represented the. And you'll see those sort of align with the timelines there that Dara's going to talk about at the end of the initial active response. And then communications to the media. We were trying to be transparent as much as we could with the media. So put out that first press release on the 3rd, shared the communication that I shared with you on the 11th with the media as well. Spent some time on WCLO, and then had that interview with NBC 15 that I had also let you know about as well. So communications. This is really the framework for why we communicated as we did during the response. And we can come back to this. It'd probably be better if we wait till the very end to do questions. So at this point, I'm going to just pass it along to Dara so he can talk a little. You talk from there.
Sure. Yep. Okay. All right. So normally, when I'm in front of a group, I don't like to read much, but I don't want to leave anything out. We want to give you as much as we can. So first of all, thanks for the opportunity to get to address this tonight. It's something we would have liked to have done earlier, but as Josh alluded to, trying to keep things put the county in the least amount of risk as possible. So I want to start with. We're in that order. Ransomware, what is it? So ransomware is a type of malicious software that's designed to block access to a computer system until a sum of money is paid. So they're trying to hold you hostage. As cyber criminals continue to look for new and innovative ways to infiltrate organizations, it's important to remember that ransomware is a criminal activity. It has affected many local, national, international organizations, including Taiwan Semiconductor, Caesar's Palace, MGM, American Family, Quick Trip, Minnesota Public Schools. I think we've got a couple more on there. You can add the University of Michigan, you can add Johnson Controls, CDW, and that's all within the last few months. September was the busiest month in history for cyber attacks, and the expectation is that's going to get worse. So, of note, many of the ransomware attacks that occur are not reported at all, or at least not made public. Okay, so unfortunately for us, on September 29th into the morning of the 30th, Rock County experienced a double extortion ransomware attack. And so a double extortion attack is when the threat actor exfiltrates a victim's sensitive data in addition to encrypting it, which gives them additional leverage to collect a ransom payment. This criminal organization requested $1.9 million ransom to retrieve the encrypted files. Upon confirmation of the attack, Rock IT contacted with our insurance carrier, Cowbell, and that isn't a misprint, Cowbell is their name, on Saturday morning, September 30th. Rock County retained Mullen and Coughlin Law Firm, who retained and dispatched a crisis response team from Booz Allen Hamilton. We tried to respond quickly. We pulled the internet connection to our network. We started taking systems down so that the threat didn't go further. Booz Allen arrived on the morning of October 1st, Sunday, the next day, and they began triaging and assessing the systems and then working with us to try to clear systems and start bringing them back online. During the triage and assessment period, Rock IT worked with the team to complete an identification of all affected systems, and then we achieved a broad deployment of an endpoint detection tool called Carbon Black to all of our systems. You all have it on your laptops, to help identify and protect against further malicious activity. And since the event, we have not seen any signs of persistence or unauthorized access to our system. So Carbon Black is an endpoint detection tool that continually feeds information to a centralized operations center that's called Deep Seas that does 24/7 monitoring. All right, so Rock County has about 150 servers. 32 of those were affected. We had only 2 laptops network-wide that were affected. The main services affected included public safety, human services department, the medical examiner, and Rock IT's internal systems. Most affected services have been restored, but we are continuing to work fully to restore Citrix, human services access database, Esri access databases, and the jury managed system at Rockhaven. Furthermore, it's important to note that the bad actor did not gain access to county information systems via an email or through a user action, nor did they, Therefore, our business emails were not compromised, and with the reset of all the county user accounts, our Office 365 tenant was considered clean. Over a 2-week period, Rock IT worked with our contractor partners to remediate and restore most services and applications. Upon completion with our partners, some state agencies elected to postpone restoring access until completion of triage and assessment, but the state agencies did restore connectivity on October 12th, and then CCAP came on October 26th. In consultation with our insurance carrier, Cowbell, and again, Cowbell, we have had to put a ban on using the phrase, "we need more cowbell," within our department. And with outside legal counsel, Mullen Coughlin, Rock County did not pay the ransom. This was due in part to having sufficient backups available to restore from. So, current strategy. Rock IT has worked hard to implement a cybersecurity first strategy. Currently, Rock County has 3 prioritized strategic pillars on all initiatives and efforts must align to. These include cybersecurity, operational efficiencies, and user experience. While Rock IT considers all 3 pillars, we've adopted a cybersecurity first approach. This security first approach at times leads to operational inefficiencies and user frustration, as experienced by the MFA authentication, all the little things you guys have to push to log in. MFA is necessary for security authentication purposes, but it does create frustration among users. Despite that frustration, it is necessary, and that is the approach that Rock County has taken and will continue to take. As mentioned, Rock IT has been working hard the last several years to both modernize our infrastructure and work towards cybersecurity best practices. To support the development of that strategy, Rock IT retained Baker Tilly to conduct a cyber assessment in 2019. And ROC IT has worked to implement many of the assessment recommendations. As a result of the assessment, ROC IT has taken a three-pronged approach to diversify where ROC County's official systems and applications reside. So first, starting in 2022, we moved several of our on-premise systems and applications to vendor-hosted platforms. These include Bastion for the Register of Deeds, Avatar for the Human Services Department, and Office 365 for Teams, SharePoint, and Office products. Dayforce also went to the cloud for human capital. There are additional critical applications that we have plans to move to vendor-hosted in the future. These include Laserfish, Financial Enterprise, Rockhaven's new electronic health record, and the tax system. The advantage of vendor-based hosted systems is that it's very robust disaster recovery platforms they have, and it also helps ROC County diversify by moving systems around. They're not all in one place. We've also moved our remote access tool, Citrix, to the cloud to enhance security. And finally, for those applications that remain on-premise, we're developing a full disaster recovery Site B. This will allow us to fail over from our primary data center to the secondary site in emergency. This to be completed in 2024. So as a result of the Baker Tilly audit, IT began modernization efforts as well as efforts to improve our cybersecurity posture. This slide shows some of the stuff that we've done between 20 and 22. And then these are items that we've worked on in 2023. And as noted on the slide, some of these items were brought forward a little earlier due to the event and trying to improve our security posture. And then last, these are items that are on the 2024 schedule. And so with that, turn it over to Rich.
Did my microphone turn on? It did, okay. So I'm going to talk about the data and notification review process that we're currently engaged in. So as you heard from Dara, we, through our insurance carrier, Cowbell, we're provided outside legal counsel through a law firm in Pennsylvania named Mullen Coughlin. All Mullen does is data breach law. That's it. That's their whole shop. And so they're going to assist us with all of it, the critical incident response, but then going forward, the long tail of this, which is our data breach and notification obligations. So Rock County is a hybrid entity, so that means some of our departments are covered by HIPAA, but some are not. So that creates a circumstance where we do have circumstances where if a system was accessed and that system contained protective health information and that was an unauthorized access for which the actor could have gained that information, we're going to have obligations to notify the individuals whose information could have been accessed. And we'll have to notify both the Department of Health and Human Services, the United States Department of Health and Human Services, and individuals. So just because someone receives a notification doesn't necessarily mean their information was accessed or was stolen. It just means that it could have happened. Okay, so the process really involves three prongs: investigation, data review, and notification. So we've kind of completed the investigation stage of that. We know at this point, and we have at least have a pretty certain idea about what systems were accessed and the totality of the possible data that was subject to the breach. So now we're on to the data review section of that. So that will include sending out that data to a third-party data mining company, and basically they go through the set of data with some complex algorithms and even sometimes by hand, and they try and identify whether there was PHI or even sometimes PII, and if there was, then they'll note the individuals, the information, and they'll log all of that for us. And then when we get that information back, we commence with the notification process. So we know Human Services was accessed, and we know that there is PHI at Human Services, and in fact, we know for sure a couple of sources of PHI. So we already have a fairly robust data set that we know we're going to have to notify people in, and so we're going to start the process. It'll be a tiered and waved process. We will start notifications probably next week, possibly the week after, depending on just whether the timelines and vendors that we get lined up and what their availability is. And people will probably start receiving letters that their information may have been breached. At this point, we don't have any information that suggests that the threat actor
accessed the new Dayforce system or the old ePersonality system. So there's no indication that employee data was directly accessed in any manner. But there's going to be personal identifiable information that was in department files about certain employees that may have been accessed. And in those cases, we will provide notification to those employees specifically. But there's no mass leak or distribution of employee data directly to the threat actor or online. So that's really it for me. And then, okay, that's for questions. Any questions? Supervisor Stevens?
And you may not be able to answer this, and I understand that. Thank you. You may not be able to answer this, and I understand that. Health information can you say whether that was targeted information that they were looking for, or no? Because it just seems strange that someone's looking for health information.
I don't really have any information about what the motivations of the threat actor are or aren't, so we can't really say what their motivations was, other than to get paid, right? This is a criminal enterprise. It's a economic operation. They do these attacks systematically on mass scales, and then they hope that they've damaged the entity enough and that the entity has enough insurance that they are willing to pay for the decryptor key. So I don't think they particularly care what information they get, so long as it is sufficiently damaging to the entity for us to be motivated to pay for the decryptor key to get our data back.
Okay, thank you.
Yep, Supervisor Cullen.
I assume Cowbell picked up the tab for this?
They will be picking up most of it, yes.
So will the county let us know what it actually cost us above and beyond what insurance will do?
Yeah, we should be able to do that.
And the second question, what did we learn from all this?
Again, I don't want to get into a lot of details, but we've made a lot of changes and we've learned a lot. I mean, yes, I'll say that. At a future date, we may be able to give more, but.
All right. I think the most that we'd say right now, if you look back on the slide, and Darren went through it pretty quickly, but you look at the 2023 slide, there were several things that we've done. It's fine. The 23, it includes things that, as Darren said, we moved up. That I think it's fair to say we felt that it was worth moving those up because things we learned, right? And I think one thing that we talked about among us as we were even preparing this was that, we wanted to, on the one hand, you've heard me say that I think that Rock County, despite what happened, and it seems like it's a horrible thing, was in a very good position to be able to weather this. And it was based on the things that Dara had on the screen. We talked about what happened in 19, 20, 21, and 22. And we also want to communicate, we want to be a learning organization, that we do learn things. And so I think what we've learned are some of those things we moved up sooner to get them done that might have been in the pipeline. Some things on that list we might not have otherwise done, but were recommended. And then some things that are in 24 were already in the queue to do, and we're still doing those. So as Dara said, I don't think we're getting too much into the details of specifically because, if we do much more of what I've said and we put on the slide, that gets into that point that I made earlier about, well, what was maybe the threat vector, that we're trying to address. And so as Dara said, maybe as we get a little further down the road, we can be a little more specific about that. But just to confirm what Dara said, there were things that we learned and that we made changes about.
Just to echo what Josh said too, I think one of the things we learned was we were on the right path. We hadn't quite gotten to the point where we were going to be completely insulated, and we'll never be completely insulated from one of these events, but the reason why we could function through the event and we made the choice not to pay the ransom is because we were on the right path and we had systems in place, and now we're accelerating some of that work forward into, sooner rather than later. I think Supervisor Zorel had his.
Yeah, I jotted a few questions down. The first question is, can the board please have a copy of all the slides electronically? Mm-hmm. And the next question kind of goes into what Supervisor Cullen was asking about with cowbell. Do we have a dollar total so far in terms of what the county has spent versus what cowbell is picking up, so we know what our
I don't
damage
have the figure off the top of my head. I've got bills and I've got coverage letters, and we'll sort through all of that, but I don't know it off the top of my head.
And when that type of stuff is covered, I've got to assume that a huge portion of our cost is employee labor, where you've got people who had downtime that, they're on the clock working and they can't enter and use the computer system they normally would, so maybe they're doing it by paper or whatever. Then you also got labor for your IT guys to to get it back up and running. Are those types of expenses that a company like Cowbell would cover?
So I'm not going to talk about the specific kinds of coverages and their limits, because I don't want to incentivize a threat actor from being able to manipulate that information and hit us again and then hit us where it hurts, and so incentivize us to be paying the decryptor key. But our coverage with Cowbell is robust.
Would it cover something like paying the ransom if it made sense to pay a ransom?
I'm not going to talk about the kinds of coverages that we have.
What is double extortion?
Well, as Darius said, yeah.
Yeah, so it basically means that they steal some data from you to try to hold that over your head, like, hey, we have this, so pay us because we have this. So there's a form where it just encrypts, and there's a form where they encrypt and pull. And those aren't necessarily always equal, but that's the difference.
When you say encrypt and pull, is it the encrypt and pull that goes from single to double?
Right.
And encrypt just means you're locked out.
Right.
And when you say pull, what does that mean?
It means they're also holding a copy.
So they're retaining a copy on their end to do with whatever they want. We could, pay us or we're going to release it kind of thing.
Traditionally, they're trying to sell it on the black market, traditionally.
Okay. And then a few county board meetings ago, we had an auditor here from Baker Tilly that stated that we had a problem with not updating employee passwords, and that it was a recurring problem over several years. What is the reason that we never took care of that?
So specifically, they said last time that IT had said they did it, but we didn't complete the form the way they wanted. So we did do it in 22, and we did it in 23, but we didn't have somebody sign, I did this, and here's the date I did it. So I have talked to Baker Tilly since that presentation. So for the next audit, we have the form as they wanted, but the work was done.
Is there a record to prove that it was done, even if it wasn't signed?
Yeah, because we put out MFA last year, so if everybody didn't get a token, they didn't get a login.
All right, thank you.
Supervisor Towns.
If I remember from the slide back, you said that the access wasn't made through a laptop or a hack or a current user. But did you say how it was made?
No, we're not disclosing that. We just wanted to make it clear that it wasn't a user action. It's like it wasn't Randy's fault.
We don't want to provide a roadmap to other systems that may use the same systems that we have and give threat actors an opportunity to leverage that against other people, and we don't want to encourage them to keep trying on our systems either. So we're not talking about the specific threat vector. We do know how it was accessed. Supervisor Peer.
Thank you. I just want to compliment you guys and everyone else that was involved with all the hard work. And I think it's an excellent idea not to give them any attention or information as to what's going on. I wish more companies and people that are affected in any way would do the same thing, and perhaps that would discourage some of it. Thank you.
Is this still under criminal investigation? I mean, are police, FBI involved in something like this?
I actually had correspondence with the FBI this afternoon, so I wouldn't have high hopes, but they know about it, and we've been in communications. Supervisor Stevens.
Wasn't Quick Trip fairly recent?
Mm-hmm.
Matter of fact, we were blamed for Quick Trip.
Okay, so
Just
Quick Trip was
anecdote.
just like a week or 2 ago, wasn't it?
A little longer than that, but
Yeah, okay.
yeah,
Well, you said everything up there was September?
Yeah, everything that was on that list, all those companies are since May or more recently.
Okay, yeah, I thought I read about Quick Trip being down for, what, a day or two?
Oh, it was longer than that.
It was longer than that?
It was pretty much just the reward system and the replenishment system. So, you know, like Mountain Dew ran out for a while, those kind of things.
Darrow was very concerned. All right, if there's nothing else, I think we can move on. Oh, sorry.
Rich, if you're talking to the FBI, don't let them know I'm a county supervisor.
Don't let them know you're here.
And as we transition, I just want to reiterate again, as I said during the budget meeting, that, and I think Supervisor Zorro alluded to it, that our ROC IT staff and really our staff throughout the organization spent a lot of hours not only responding and trying to resolve and mitigate, but to pivot is the word one would use to make sure that we continue to provide services to the public, whether it was recording on paper or whether it was working from home because they could access it better in that way from in the office or whatever it was. So just really want to thank all of our staff and the work they did, which really allowed us to be in the position we are today where we did not have to pay that ransom. There was very little public disruption to services, and we're in a much better position than a lot of other organizations. So thank you.
Next item, please.
Next item, 11, new business. 11A, supplementary appropriations and budget changes. 11A1, accepting additional 2023 high-intensity drug trafficking areas grant funding and amending the Sheriff's Office 2023 budget.
Moved by Supervisor Beaver, seconded by Supervisor Baumkamp. Supervisor Beaver?
So this is additional funds that will be added to our HIDA funds that are already allocated. They gave us a little extra money because of the work we've been doing and we had good results out of it, so they wanted to provide us with a better opportunity to do a little more. Any questions?
Questions, anybody? Seeing none, this is roll call. Please vote.
Supervisor Towns? Yes, 25, no, 0, 4 absent.
Next item, please.
Next item, 11D. 11D1, acceptance of Wisconsin Department of Natural Resources County Conservation Aids Grant, CC 24-54 WH funds.
Moved by Supervisor Mahwini, seconded by Supervisor Sweeney. Supervisor Mahwini?
Getting pretty good at that. I'd like to call Mr. Trainer up. As long as they're sitting here, they might as well pass the buck.
Good evening, everyone. So these grants are funds that we basically apply for every year. It is a maximum amount of $5,000. That's why in the resolution it states that there's $5,000 budgeted, but it's all up to the DNR and what we're awarded. So this year we were actually awarded $3,500 to be able to help with some invasive control and some other woody vegetation, stuff like that out of Heritage Park. So.
Questions? Seeing none, this is roll call. Please vote.
Yes, 25, no, 0, 4 absent.
Next item, please.
Next item, item 11C, amending the Rock County Land Information Plan.
Moved by Supervisor Sweeney, seconded by Supervisor Mahwini. Supervisor Sweeney.
Hi, good evening. I'm here on behalf of Michelle Schultz. This resolution is simply to amend the land information plan. The reason it's being amended is because there was a decision made to move the next ortho imagery flight up to 2024 rather than what was planned for likely in 2025. So in order to be eligible for other funding, outside funding sources, the land information funding sources, it has to be in our plan. So this is simply a plan amendment. There's no money tied to it. Any other contracts would take separate county board action.
Questions? Seeing none, this is roll call. Please vote.
Yes, 25, no, 0, 4 absent.
Next item, please.
Next item, 11D, establishment of an ad hoc Rock County Youth in Governance Program Exploratory Committee.
Moved by Supervisor Wilson, seconded by Supervisor Holman. Supervisor Wilson.
Thank you, Mr. Chair. We have a great opportunity here, and I think that Max Olson, when he spoke to it, outlined it rather well and probably can say it much better than I can. This is a program that does exist in a number of other counties in the state, exists quite successfully, and I think the benefits go two ways. There are things that the young people involved will learn from us, but we certainly will learn from them as well. This is an exploratory committee, and the reason the resolution made it an exploratory committee is so that we can heavily involve a variety of different sources, but one of those sources is UW Extension Rock County, who will be involved in this program. The extension offices in a number of counties are involved in this program and have considerable experience with the program. In a lot of ways, we're using Racine County as a model because they've developed kind of a robust guidebook for it, and we'll be looking at that and considering a variety of different possibilities and options. Some of the options include the involvement of young people with committees, attendance at committees and as non-voting members, but allowing them to participate in some activities. Some programs have job shadowing opportunities for people to work with people in various departments that may be of interest to them. So we're exploring it at this point, and the resolution calls for an ad hoc committee to return to the county board with their proposed plan by April 1st. Thank you.
Questions? Supervisor Zorel.
Thank you, Mr. Chair. I received a lot of constituent feedback on this issue, and my constituents are not happy with this particular resolution. One of the concerns that was raised is that age is a protected class, and this program is discriminatory based on age because the program is targeted to allow young adults to participate on select committees, and our senior citizens have just as much right to participate, if not more so. Additionally, some questions I have that they would like asks. Number one, what's the cost of creating this committee?
I don't know what the fiscal note indicates that it's primarily the per diem during the ad hoc period, and that there is some mileage that could possibly be involved.
Where are the funds coming from to pay for this new committee?
Mileage and per diem payments would come out of the same county board account that all mileage and per diem payments come out of.
Are we paying staff to attend the meetings? And if so, how much are we paying staff to attend?
It depends which staff we're talking about. If Randy's attending the meetings and you're not really paying him because the private meeting may be after school, it could be in the evening, right? And so Randy's paid a salary, I'm paid a salary, right? Somebody's there to take the minutes, then yeah, you probably are paying them an hourly wage if it's after 5 o'clock, for example. But it's hard to quantify that. We don't know how many meetings or when they're going to occur yet.
So given that you may have some additional salary costs, you're going to have additional meeting costs, you're going to have some additional mileage costs, will the budget need to be modified to pay for this new committee?
The cost of the committee, whether it's staff time or mileage, we would consider pretty marginal, and in the normal course of business that we'd expect to have expenditures in the county budget in any given year.
Is there additional slack in the county board budget, in other words, to cover the creation of a new committee like this, is what you'd be saying?
I think just about every year that I've been a county administrator, there's been at least one ad hoc committee created, and sometimes multiple ones. I think you've experienced in the last this term. So we do expect that some things like this will occur.
What specific metrics or outcomes will define the success of youth and governance program, and how will these be measured and reported?
I guess I'll respond to that, and the answer to that is we don't know what the program will look like yet. I think part of the ad hoc committee's work will be identifying some of those outcomes.
Youth in our community are already welcome to attend our meetings, either in person or via Zoom. They aren't attending now. Why should we create a whole new committee when instead we can encourage youth to attend committee meetings we already have and participate in the public comment sections?
Actually, the genesis of this committee was Max Olson attending a committee and asking the chair of that committee if there was a way for young people to be involved. That committee chair said the way to go about this would be to talk to your supervisor. I happen to be Max's supervisor, and met with him, did a little bit more research, and felt that this was an excellent way of involving young people. Let me address one of the other concerns you mentioned, participation of senior citizens. I would suggest that senior citizens are pretty well represented on the board. In every committee, I think that speaks for itself. This is a group that's underrepresented and whose voice is an important one to hear.
What would be the reason that we just couldn't encourage the underrepresented group to just run for county board? Why do we need a special program for them but not other people?
Running for county board, they would not be eligible, and depending on who. There's no restriction in terms of who might be involved in this program. We could set some parameters. Some of the parameters do include college students, and at least some of those, and in some cases, high school students might be eligible to run for county board. And this, in fact, may be a path that would encourage some people to follow that path.
How will youth participants be selected, and what measures will be in place to ensure that these positions are not subject to favoritism or political influence?
Very good question. And I mentioned the Racine County Guidebook. We do have some indications of how it's being done in other counties, but we'll be examining that very, very carefully. When I attended the Ag and Extension meeting to present this to them, one of the handouts that I provided was a sheet that had the pictures of those young people who are currently participating in the Racine County program. The group represented many of the high schools in Racine County, represented a variety of different backgrounds and races as well.
Has there been an impact assessment on how this program might affect the current workload of the county board supervisors and staff?
Not to my knowledge.
What tangible benefits does the board expect from this investment in terms of community engagement and youth development, and can these benefits be quantified?
Again, the program hasn't been developed yet, but let me give you some examples. There are decisions that are being made by some of our committees human services, the public safety that impact young adults, and having the voice of young adults represented in some of those discussions would be very valuable.
What legal liabilities or additional responsibilities might arise from involving youth in governance, and how are we prepared to address them?
I would just reiterate, I think what Supervisor Wilson indicated, it's hard to answer some of these questions before the program is developed, and I think the answer to that question would depend on what is recommended out of the ad hoc committee.
What other opportunities for youth engagement and leadership development have been considered, and why is this program deemed the most beneficial?
It may not be the most beneficial. That's why we have an exploratory committee to look at it and make recommendations.
What mechanisms will be in place to gather feedback from both the youth participants and the community about the effectiveness of the program?
Again, yet to be determined.
How will the program ensure continuity and maintain institutional knowledge as youth participants cycle out?
You repeat the question?
How do we ensure the program being continued and maintain institutional knowledge as youth participants cycle out?
I think, again, we don't know the answer to that question. If the program turns out to be non-productive, my guess is that the program would not be continued. In the case of at least 6 counties that I'm aware of, they have ongoing continuing programs.
How will the program ensure a balance of diverse viewpoints among the youth participants, reflecting the full spectrum of political and social perspectives in our county?
That's going to be part of the duties of the ad hoc committee to make sure that that happens. That issue has already been raised. I'm certainly aware of it, and I'm sure whoever is appointed to this committee will be cognizant of it.
What transparent processes will be implemented to ensure the selection of youth participants is fair and unbiased, free from political or institutional favoritism?
Again, what comes out of that ad hoc committee will ensure that.
And what steps will be taken to prevent the program from being influenced by any external political organizations or agendas?
I think that the recruitment process would be broad. I guess the only thing that I can speak of directly is the fact when Max Olson approached me about this, I said, let's go out to lunch and talk about it. We went out to lunch. I think Max would concur that I never asked him what kind of political beliefs he had. I asked him things like, what spurred your interest in government? I already knew by example that he was involved, as he mentioned. He's serving on the Parks Board in Milton. So that political affiliation or political slant is certainly not something that we're considering as a metric.
Those are all the questions. Thank you.
Supervisor Stevens.
Thank you, Mr. Chair. I think we can all agree that every 2 years, there's a possibility that we're going to have new county board members who are not familiar with local government, who are not familiar with county board, who are not familiar with how things work. So many times we hear people saying that our youth are just sitting around, they're not doing anything, they're just playing on social media, they're playing on their phones, they're playing computer games, they're really not doing anything. We have an opportunity here to encourage the youth to get involved in local government. And by doing this, we have an opportunity to, when they're in high school, from freshman year to senior year, for them to have plenty of opportunity to learn how local government works. So by the time they actually do run for county board, they know how it works. I think for me, that's a great thing. Because I think there's quite a few of us in here who can say that when they got seated, they didn't know what was going on. They didn't know what was going on. They didn't know how county board worked. And they had to ask a whole lot of questions about, wait, what does that mean? Well, how does that work? What is called a question? What is that? Right? We know that. But if we can get the youth to start learning all of that in high school and get them used to how local government works, and they're actually interested in learning about how local government works, get them interested in that. It's like any other thing. Math, you get them interested in that, you get them interested in a career. Why do some people here have a problem with wanting our youth to get interested in a political career when they're in high school? We don't have a problem with them wanting to be interested in being a doctor or a lawyer or a teacher. So I don't see a problem with wanting to create something that gets our youth being interested in having a career in local government, state government, federal government, getting them started on a local level. I will be supporting this. Thank you.
Supervisor Crary.
Thank you, Board Chair. Yeah, Supervisor Stevens just said a lot of what I wanted to say, but I also want to thank Max for doing what you've done, because I think it takes a great mind and it takes a lot of courage at your age to reach out and say, this is what I want to do. And I'm very proud of you. And thank you, Supervisor Wilson, for taking those extra steps. When I applied for appointment, there was one other person that applied. When I ran for county board, there was one other person that ran in my district. And a lot has been said about Gen Z being one of the most politically involved and civically involved generations in many, many generations. And this serves to continue that trend. And I personally love it. And I am not scared of having our youth involved, because I think we can learn more from them sometimes than they can learn from us. And that is exciting. So I look forward to seeing Max sitting on the county board in the future, and I look forward to seeing his peers here as well. So I support this wholeheartedly, and I hope I speak for the rest of the board.
Supervisor Towns.
Thank you, Mr. Chair. I'm going to surrender my time. I think Supervisor Wilson covered anything I would have said about this in a much more patient way, so thank you.
Supervisor Baumkamp.
Thank you, Mr. Chair. Several years ago, they had City of Janesville had a program, something like this. I think there was a young Tom Bryan that I got to be with way back when. But yeah, I used to be involved with Rock County 5.0. That was for Janesville. James Otter Street they had a thing going, and it was for different programs, different things. It was to get the youth involved, and it'd have somebody to go to ask questions. They'd send you emails. Everybody was vetted. It's a great program, and we have to get the youth involved. So often we hear our youth are lazy. They don't want to do anything. Well, why would you be against this? To have somebody do this, to come in, and they might say, this is not for me, or they say it is for me. So this is a great thing. With all the unknown questions that we're just not, it's obvious we need an ad hoc committee. So I'll be voting in favor for it.
Supervisor Mahwini.
Thank you, Mr. Chair. Many moons ago, the Milton School Board took on youth. And, you know, I was sitting on the board at that time, and you kind of went, oh, what is this going to do? But it's amazing, the input that they have. It was excellent. And they showed up. For as busy as these kids have been, they show up because they think it's important. I will be supporting this.
Others. Supervisor Sutherland.
Thank you, Mr. Chair. Any doors that we can open for the youth to defend and participate in democracy is good. I'll be supporting this. Thank you.
Others. This is roll call. Please vote.
24 yes, 1 no, 4 absent.
Next item, please.
Next item, item 11F, authorizing purchase of Rock County Transit vehicle.
Moved by Supervisor Knutson, seconded by Supervisor Woodman. Supervisor Knutson.
Thank you, Mr. Chairman. The Human Services Department's Aging Unit operates the Specialized Transportation Program to provide specialized transportation services for seniors and individuals with disabilities. The Aging Unit requires a fleet of 12 buses to meet the contractual requirements of the Specialized Transportation Program. 3 of the vehicles are expected to be inoperable in 2024 due to normal wear and tear, age mileage, and excessive repair costs. In addition, securing vehicles has been a continuing issue. Wait lists can be 6 to 9 months. Rock County submitted a request to the Wisconsin Department of Transportation for funding to purchase 3 vehicles. We received notice that we received funds to purchase 1 vehicle at the cost of $143,340. The Department of Transportation will reimburse Rock County 80% of this vehicle's cost, and Rock County will be responsible for the remaining balance of $28,668. We would appreciate your support.
Comments, questions? Supervisor Zorro.
Thank you, Mr. Chair. How do we know as a county board if it makes financial sense to continue going out and buying and maintaining our vehicles and paying staff to run those vehicles as opposed to outsourcing that to some other contractor?
Well, I'll start, and then if I don't answer the question, or if Kate has anything to add, I'd invite her up. So historically, and for many years, even before Human Services took over the Specialized Transit Program, we did investigate, putting out proposals for operating the program. Other municipalities, we provide paratransit for the cities of Beloit and Janesville that they are required to provide because they operate federally funded transit programs. They put out RFPs, and there are no other vendors who have responded for years. We are the only vendor really that is out there to provide services to the cities, and therefore that's a pretty good indicator that there's no one who's out there to take over our program. So we view the Specialized Transit Program as filling a gap in the community that no one else is there to fill, and that's why we continue to want to support that for the community.
Others? Supervisor Cullen.
What's the life expectancy? How long do these vehicles last?
Yeah, it's a good question. Kate, do you know?
I can say 200,000 miles, and we average, oh gosh, I don't have that data in front of me, several years, and 200,000 miles before they get retired if we can help them stay that long. We have part of the KIP is a kind of a rotational plan to make sure we're rotating vehicles in and out so that we have enough at any given time. So this is just us trying to kind of keep up with the need.
How many vehicles do you feel you have to have at any one time?
Nice try though, Kate.
Okay. So sorry for those of you who couldn't hear me. What I said is I actually don't know how long our vehicles last on average, and I don't have those staff who have those answers here tonight. But it's about 200,000 miles before we retire a transit van, and we have a fleet of 12 buses. I'm sorry. What is the question I'm answering now at this point?
How many do you have operating at one time on a typical day?
Oh, on a typical day, we would have most of them operating that we have operational on a typical day. So we don't have vans just sitting that aren't being utilized. It is typical that we don't have all of them in operation at any given time because they're out for service. And so we have a fleet of 12. We have, like for example, the data we have here is that there's 3 expected to be inoperable coming up. At any given time, I would guess about 3 or 4 that are getting serviced that day or out for maintenance. And so I don't want to say with specificity on average we have 9 per day, but there's usually most of them operating, and some of them out for service. So we try to have enough so that we can meet the need.
Any idea what you paid for the last vehicle?
I don't, it was less than this, and I don't have that, I have that, had that pulled up on my laptop earlier, but I don't have that right now. And this is a situation where because of supply chain issues and demand, we have really been waiting when we're sometimes at the mercy of what we're able to get for the cost that's being provided, and then the state pays us 80% through the grant program. And so this is a higher price than we've paid in the past, the $143,000, $340,000. However, the last few that we purchased, which were 2022 budgeted carried into 2023, were not far off of this, if I'm remembering correctly.
Thank you.
Others, Supervisor Sutherland.
Thank you, Mr. Chair. So this transportation is for the elderly, for handicap, for making appointments, for health, stuff like that. So we certainly wouldn't want them driving themselves, correct?
Correct, and they can't, which is why or often struggle and have barriers for transportation.
Difficult for them to walk to the corner for the
Yes.
bus, that kind of thing.
Yes.
And I know you said you have maybe 2 or 3 out of service for maintenance or whatever, but do you have an approximate number of deliveries a day? Like how many people a day approximately, or a week?
The average is 114 rides per day.
Thank you.
Others? Seeing none, this is roll call. Please vote.
Twenty-five yes, 0 no, 4 absent.
Next item, please.
Next item, item 11G, authorizing the land transfer between adjoining landowners, Wisdot Land Purchase, Lee Park.
Moved by Supervisor Mahwini, seconded by Supervisor Woodman. Supervisor Mahwini.
Thank you, Mr. Chair. This is down on Highway 140, east of Clinton, or south of Clinton, I guess, south of Clinton. Some improvements include widening of the existing road, Highway 140, and improvements to the intersections along the corridor. WISDOT needed to have some land, so they're going to purchase 1.31 acres for a cost of $34,100. It's for additional land, monetary amounts for the values associated with the potential trail relocation. I'm doing well here, too. We recommend that you take it. It's pretty good for 1 acre of land. John's here if you have any other questions.
Questions, anybody? Seeing none, this is roll call. Please vote.
Twenty-five yes, 0 no, 4 absent.
Next item, please.
Next item, 11I, authorizing double fill of administrative professional 3 position.
Moved by Supervisor Beaver, seconded by Supervisor Baumkamp. Supervisor Beaver?
This is a resolution requesting a double fill outside of the normal 4 weeks that are currently is provided in the ordinance for the mediation office. That office has 2 staff, and their administrative professional is going to be retiring effective February 1st, but she's leaving office on January 5th to use accrued vacation. So they're requesting a double fill so that we could get somebody in to train with that administrative support before she leaves the office.
Questions? Seeing none, this is roll call. Please vote.
Yes, 25, 0 no, 4 absent.
Next item, please.
Next item, 11J, awarding $200,000 in opioid settlement funds for youth substance use prevention initiatives.
Moved by Supervisor Pierce, seconded by Supervisor Crary. Supervisor Peer.
Thank you, Mr. Chair. I know there's been a lot of concerns and questions as to how the opioid settlement funds will be allocated. So this resolution authorized the release of $200,000 in opioid settlement funding to youth prevention coalitions, and they were identified through a competitive grant application process to address youth substance and use prevention. As the board members know, on August 10th, 2023, we passed Resolution R 2023-277 to adopt an implementation plan for the use of opioid settlement funding being received by the county to address and abate the harms associated with the opioid epidemic. The implementation plan allocated $100,000 a year for 2 years, so a total of $200,000, to fund evidence-based youth substance use prevention initiatives completed by Youth Prevention Coalition serving Rock County. I might add that Rock County is, I don't know how to say this exactly, well represented in this funding. Unfortunately, well represented means we had quite a problem, but we are represented well in terms of money for the abatement. The Rock County Public Health Department created a request for proposals, REP or RFP, to solicit applications from eligible organizations for the funding. In total, there were 5 applications, 2 for an award of $70,000 per year for 2 years, $140,000 total, and 3 applications for an award of $10,000 per year for 2 years, $20,000 total. An application review committee consisting of representatives from Human Services Department, Sheriff's Office, Rock County Public Health Department, who have these are the experts that have in the subject matter in substance use prevention. They reviewed all the applications against the scoring rubric, and the rubric considered the applicant's staffing and organizational experience, goals, and measurable objectives. Also, the implementation plan that they put forth, strategy for reaching people most at risk, data collection and performance measurement strategy, and proposed budget. So as you can see, the decision was not made willy-nilly. Good quality oversight, responsible decision-making in putting this forth. So the committee recommends funding the organization listed in the chart that you were provided, and I'm sure you can see that, and there's an outline for each organization that it was awarded to and what exactly they were going to do. I think it's worth noting those. I know there's citizens out there concerned about how we're spending our money, and supervisors as well. So Janesville Mobilizing for a Change, remember they got $140,000. They will be providing an evidence-based program called Teen Intervene to at least 20 at-risk youth referred by their schools. This program will be available to all school districts in Rock County. They will also use the funds to support at least 3 youth leadership groups. Next is Youth to Youth. We'll implement a mental health curriculum managing My Mental Health at 2 after-school programs in Beloit for a cost of $20,000. The Milton Youth Coalition will offer Strengthening Families, an evidence-based program for families with children aged 10 to 14 years. It is shown to improve communication in families and subsequently reduce substance abuse and delinquency risk factors. They will also support or provide support for a youth substance prevention society at the cost of $20,000. And lastly, Building a Safer Evansville. And it will implement 2 evidence-based programs, Persuade, Refer, which is a suicide reduction program, and Catch My Breath, a vaping prevention program at the cost of $20,000. So you can see There's a lot of problems that are going to be addressed here, and we fully ask for your support. If there are any other questions, we have our health officer here, Katrina Harwood. Thank you for your attention.
Comments, questions? Supervisor Zorro.
Thank you, Mr. Chair. Given that the opioid epidemic disproportionately impacts white Americans, how does this program help us achieve our equity goals and reduce racial disparities?
I refer any questions further to our health officer, Katrina Harwood. I would like to make a comment, though. I think in a partial answer to that is there's a multitude of questions that could be asked that this doesn't address. This isn't all the funding that's going to come through. This is the beginning. And I don't think any program's going to exhaust all the possibilities to solve all of the needs that one might come forth. I think some people are very creative in all the questions and thinking about the universe, and they're questions people and they're action people. And I think it's just a real good start to address the problem. You got to start someplace. Doesn't mean you're going to finish. I don't think this drug problem is ever going to be finished, to be honest with you. Thank you.
Supervisor Zorro, could you please repeat your question?
Yes, so given that the opioid epidemic disproportionately impacts white Americans, how does this program help us achieve Rock County's equity goals and reduce racial disparities?
I think there's one important piece to note about disparities, and although one population may be most impacted by number of people, we see disproportionate impacts based on race and ethnicity to indicate that there is a disproportionate impact on people of color. So although there may be more people in the county who are white, who are impacted by substance use prevention, there is a disproportionate amount of people based on the population levels we have. I will say that these programs are intended to reach all youth in Rock County, and they are intended to reach people most at risk.
Can you clarify what you mean by disproportionate amount in the county?
I would need to look at our demographics more closely, but the demographics of Rock County are, I think, approximately 90% white. And when we look at rates of overdose-related death in Rock County, we see a higher rate in Black or African American residents at a rate higher than we would expect based on their population.
So it'd be fair to say that Rock County is different from the rest of the United States in that regard?
No, I wouldn't say we're different in that regard.
Was equity considered in terms of which organizations we were picking?
We were considering ensuring that the organizations were able to reach those individuals most at risk. And those were through some of the programs will be through the school referrals.
So that would be a no?
Can you repeat what you asked so I can
Was
clarify?
equity considered in determining which organizations you were choosing to receive this grant money?
Equity was considered in regards to ensuring that those who are most at risk are benefiting from the programs.
Would you be able to forward your research, please?
And if I could just interject here briefly, I mean, I think it would be good probably to, for the purpose of the discussion, to know that when we talk about equity, equity is not just framed in racial terms, as Supervisor Zorro has done it here. There's geographic equity. And that was one of the issues as well, as you see in the resolution, as Supervisor Pure referred to it, that we're reaching, excuse me, everybody, in all corners of the county. And that we've certainly talked tonight about age equity. And as Katrina has indicated, here we're targeting those who are most at risk. And so that is an equitable approach to try to address those most at risk. So I think, again, I would not want to get hung up on a narrow definition of equity.
I understand. The reason I ask is because I know the health department has focused on race equity in the past, and I was just wondering if that was a focus on this particular program as well.
It is not the focus of this particular program, but we do look at where we see those health disparities.
Thank you.
Others? This is roll call. Please vote.
Supervisor Towns? Could you hit that again? It's not showing yet. It's not showing.
Well, I voted yes.
You voted yes, okay. So it's 25 yes, 0 no, 4 absent.
So other people did too.
Next item, please.
Next item. Item 12, executive session per Wisconsin statute 19.85 sub G to confer with legal counsel for the governmental body who is rendering oral or written advice concerning strategy to be adopted by the board, by the body with respect to litigation in which it is or is likely to become involved. This requires roll call.
Yep. This will be roll call. If you want to enter executive session, vote yes. Oh, we need a motion first. Supervisor Baumkamp, Supervisor Knutson, to enter into executive session. We will go through roll call. Please vote.
$25 yes, 0 no, 4 absent.
We are now in executive session. I'll turn things over to Corp Counsel Greenlee.